Namaskar viewers, hello and welcome to Sansad TV. I'm Tina Jha, you're watching Perspective. On the show today, we look at the Supreme Court's opinion on the presidential reference that sought clarity on whether courts could fix deadlines for constitutional authorities, such as the President and governors, to grant or withhold assent to bills under Articles 200 and 201 of the Constitution. A 5-judge bench led by Chief Justice BR Gavai opined that Judiciary cannot prescribe timelines for governors and the President to act on bills, nor can they invent a doctrine of deemed consent or compel constitutional authorities to seek the court's opinion on such legislation. Taking over the decision-making role of governors or the President violates the separation of powers, was the opinion of the bench. However, they also clarified that the President or governors cannot resort to prolonged and evasive inaction by sitting endlessly on state bills awaiting their approval. This would amount to a deliberate attempt to thwart the people's will expressed through the proposed welfare laws passed by state legislatures. So we'll discuss details of the 111-page opinion given by the 5 judges on the presidential reference. But before we proceed, a quick recall of how the presidential reference reached the Supreme Court. So in May this year, President Droupadi Murmu invoked Article 143, Clause 1 of the Constitution to seek the Supreme Court's advisory opinion on a set of 14 questions that sought clarity on the nature and limits of the powers exercised by governors and the President under Articles 200 and 201, and whether judicial timelines or deemed assent were constitutionally permissible. So in this context, we'll try and understand in greater detail about the opinion given by the 5-judge bench and whether it overturns the 8th April judgment, where a 2-judge bench framed guidelines on how quickly governors and the President must decide on bills, and in an unprecedented move also used Article 142 to treat 10 Tamil Nadu bills as having received deemed assent. To help us understand better the constitutional significance, also the larger implications of this advisory opinion, we are joined on the program by Senior Advocate Mr. Harish Salve. Sir, thank you for your time. Welcome to Sansad TV. To begin with, at the heart of this presidential reference, as we've already informed the viewers, was a very basic but crucial question. Can the courts direct the governors or the President to act on bills within a fixed time frame? How do you interpret the court's clear no on this matter?
It's very clear. The opinion is clear. The governor is a co-equal institution. See, these are all constitutional institutions. And the Supreme Court has taken the view that except where there is extraordinary delay, they can request, direct, whatever, a governor to deal with a bill. Beyond that, there is no scope for judicial review. The judicial review begins after a law is in place and not before. So all the points about the governor having a fixed timeline, I mean, we all know that the Constitution requires all functionaries to act with alacrity, to act in good faith, to act in the interest of the country and the interest of the Constitution. And we all know we live under a constitutional regime where the states have a right to make law. The state legislatures have the power and the duty to make laws necessary for the purposes of the state. So we all know that, and we all know the governor should not unduly delay. So these are, stating all this is the Supreme Court only reminding everybody of the context in which they dealt with the matter. And I'm happy that the law is now being cleaned up, in the sense that all the doubts which had come in have been resolved. Mm-hmm. So first of all, there is no absolute timeline. Secondly, there was some question about whether a bill can only be sent to the President. What happens if it comes from the President, etc. We don't need to get into the weeds on that issue. So what are the options of a governor? They have said the governor cannot simply withhold. He has to either withhold and send it back to the legislature or send it to the President. And of course, if it goes to the President, then it goes into a different situation. The President is not bound to grant consent, etc. So that's one separate chapter in which the governor may deal with it. And the other way of dealing with it is by sending it back to the House. So these are all established, accepted procedures, and they've clarified that the governor has to act in his own wisdom and in his good sense, and he can't be put into any time frame. Of course, he has to act with the alacrity the situation deserves, and no question of directing him. And the most important thing they have said is that there is no such thing like deemed approval of a law.
Right.
A law has to be granted assent to by the governor. The governor has to put his pen to paper and sign it, as the President of India has to put a pen to paper and sign union laws. So that is cleaned up, and that point is now put to rest.
So, sir, while this opinion implicitly corrects the course that use of Article 142 to deem assent is a constitutional overreach, just for clarity, does this also mean that the opinion, it's been called an advisory opinion, 111-page opinion, does it effectively set aside the 8th April ruling where you would recall the two-judge bench had invoked this particular Article 142 to create deemed assent for 10 Tamil Nadu bills?
Let's not mince words. It clearly says that view was wrong. Mm-hmm. And there's no question about it. So whether it sets aside the operative direction in those cases or not is another matter. Because I think after the judgment of the Supreme Court, those bills were signed and sent off. So that issue falls away. But it lays it down very clearly that the Supreme Court does not have under Article 142 the power to say, okay, if the governor is not giving assent, we give assent.
So at the same time, we also see that the court has said governors cannot sit on the bills for a long time. It warns against prolonged and evasive inaction. Do you see that as a balancing act or a course correction wherein the court had already, it was a matter of constitutional overreach?
Nobody should sit on anything. Parliament shouldn't sit on laws. Parliament should work with alacrity. We see Parliament all the time being disrupted. State legislatures must enact laws. Governors must act with alacrity. And the judiciary must act with alacrity and decide cases quickly now. We have complaints in every area. And sometimes as a lawyer, I feel a little embarrassed when I complain about delays in other systems. Having said that, yes, the Supreme Court only said what we all know as constitutional lawyers, that the governors must act with alacrity. That's all.
True, that's the message to the authorities. But at the same time, it says in extraordinary cases of malified delay, judicial review is still available. So how do you interpret what might qualify as extraordinary?
See, that's what I'm saying. This is there are some parts of the judgment with which, with great respect, I don't agree. If you say mala fide is in the realm of administrative law. Here it cannot mean misusing a power. It means for an oblique motive, the governor is not acting. How can you pass a verdict against a governor saying the governor is acting mala fide if you cannot implead the governor? And Article 361 is an absolute bar. Now the Supreme Court gets around it by saying the bar of 361 doesn't prevent us from testing the action of a governor. They are right. So if the governor appoints a chief minister, like we had challenged the late Jayalalitha's appointment as chief minister. So we said we are not challenging the action of we are not challenging the governor by impleading him. We are saying the governor has passed an order saying so and so shall be chief minister. That order can be challenged. But what happens when the governor is not acting? There is nothing to challenge. So there is no act. A non-action is not an act. So I don't know how this is ever going to fit without Article 361, without making a governor a party in person. You're going to make allegations saying this man is a political animal and he's acting against the interests of the state. But I can't make him a party, but still condemn him unheard. So I have grave doubts about that bit of the judgment, but that's for another day.
In fact, soon after this judgment came out, there have been concerns raised by several political parties. They've been complaining about the governors sitting on bills for months together. And now there are concerns that without a judicially enforceable timeline, what are the other remedies that they can explore?
The court is not the remedy for every problem in a democracy. The legislatures are co-equal institutions. Can Parliament or the state legislature do anything about the delays in our judicial system? Can they interfere with the Supreme Court hearing or not hearing a case? They can't. So, but the court has to have the responsibility and the constitutional duty to act in a manner that makes justice effectively and expeditiously available. In the same way, the governor has a constitutional duty to act, but not every constitutional lapse can be remedied by a court. If the governors are acting in this fashion and they are frustrating the will of the people, it's a breakdown of the constitutional machinery, and that has larger consequences. But that doesn't mean you will find your remedy in a court.
So, sir, how do you see this judgment then impacting the center-state relations going forward? There is there is a thin line of balance that we see in the judgment, but there are also certain grey areas.
At my age, I find noise to be the biggest evidence of there being a strong, robust democracy. Where everything is very quiet and very peaceful and very smooth, there's something wrong. In democracy, there always should be a little friction to show that we are alive. So these problems will come and go, political differences will come and go. Today, we have, unfortunately, a very polarized political debate at times. The vocabulary of politics has become very sharp. These are all phases. This too shall pass. So these are not permanent problems. These problems come and go.
So what do you think, sir? You've been practicing for so long as a legal luminary. Or what is the remedy? Do you think the Constitution itself could provide a solution specifying timelines for assent of bills?
Yeah, well, if it does become endemic, see, ultimately the political class has to realize that they have to get together and rise over personal differences to resolve certain issues. If the Constitution, amending the Constitution, today, you may be in power in the center, tomorrow you may not be in power in the center. Tomorrow you may be in the power only in the state but not in the center. So if tomorrow if a situation arises where everybody puts their head together and says, look, let's have a 3-month outer limit for making a bill into law, put your heads together and amend the Constitution. But frankly, if you can have this degree of harmony and understanding, the delays would stop happening. So I think ultimately there is a larger problem here, and that larger problem is there is something wrong in the way, there's some mismatch in the way in which the relationships are operating. The relationships need to be addressed. It's far more important to address center-state relations than merely seeking relief in a particular case. So, because union and the state have to work in harmony for the benefit of the people. It can't be A versus B.
That's right. So do you think this judgment gives some kind of guidance in the current structure that prevails in our country? There is a guidance both for state legislatures as well as the executive to draw from this opinion as they frame future laws?
The Supreme Court has reminded the constitutional functionaries of how the Constitution expects them to function. But the ultimate solution in all these things is there is no substitute for wisdom. There has to be wisdom in all the constitutional functionaries and an overriding sense of duty of acting in accordance with the Constitution. The Supreme Court has reminded the people what the Constitution says and how they should be acting. And I'm sure this is a problem which has passed. And I don't think, hopefully, we should not be needing to revisit this problem ever again.
Sir, the court also says that the president cannot be compelled to seek any opinion under Article 143. But is this could this be inconsistent with the need for clarity and uniformity going forward on multiple issues?
No, I'm sorry. It is for the president to seek advice. The president can seek advice of the Attorney General. The president can seek advice of whoever the president considers appropriate, and where necessary, the president can seek advice of the Supreme Court. It's It's a mechanism available to the president. You cannot say that if tomorrow a state bill comes before you, don't decide on the advice of your attorney general, come to us and we will decide. Sorry, that's not correct. The system has to work.
So, as an experienced individual, what kind of solution do you see in addressing this kind of problem? Because this is one case that has been resolved, but if there are...
We are India 75, right? India 75. How many times has this problem come up? 5? In a period of 1 year? How many times has this problem come up in the last 2 years? This too shall pass.
So can it be left to the morality of those who frame laws, but at the same time who are also giving assent to the laws?
There is no substitute. There is no substitute for the good sense and morality of those in government. Today, the union government is running the country. The states are running their states. They have to work in harmony. The political divide is good on principle. But at some point, if the states are having this problem with the union, instead of taking defiant posture that everything, we need dialogue. If dialogue goes away, the biggest loss to democracy is dialogue being thinned out. We have to bring back the culture of dialogue. We may have different points of view, but we have to bring back the culture of dialogue, of moving ahead.
You've seen successive governments in India. You've seen the political discourse shaping up through years. Where is it that you see an atmosphere not conducive for dialogue? Why is it that, that there is growing intolerance among political parties, which is leading to more disruption and not constructive dialogue?
Now you're drawing me into areas which I don't want to go. This is a political issue. I may have my own views on it, but there should be a dialogue, and that's the answer on principle. Why there is no dialogue today, you should ask an expert political commentator.
Okay, I will leave it at that, sir. One last question on, we're about to celebrate Constitution Day on the 26th. 75 years on, our Constitution has seen remarkable milestones as well. We've seen several challenges, but our Constitution has been quite resilient. It's kept up to pace with the changing times and its contemporary. But as we reach or as we embark towards our 2047 vision, what are some constitutional values that you see India needing the most in this journey over the next 25 years?
I beg to differ. India has been very resilient. India has been very robust. A constitution is only as good as its people and the people who work it. Look at our neighboring country. They've had 5 constitutions which have come and gone. You can have the most perfectly worded constitution and you can run it to the ground very easily. It is the will of the people, and I salute my nation. I salute my fellow Indians. We have democracy in our marrow. We have democracy in our blood. The one challenge to democracy in 1975 was not solved by the Supreme Court. The Supreme Court catapulted it. It was solved by the people of India. I have great faith in India, and I have great faith that 2047 is a very achievable dream.
What is your message for the young Indians who will be driving us and giving more momentum to our journey towards that Viksit Bharat goal?
For young Indians, I have only one message. I envy you. You're the part today. You're today in a part of a great journey. There's a great future for you. Do not get waylaid by. There have always been prophets of doom. Look at the positive. Look at the good. And move ahead.
All right. With that, we'll wrap up the conversation. Thank you, sir, for joining us on the program. Always a pleasure to speak to you. To you viewers, thank you very much for your time as well.
To watch more programs of Sansad TV, subscribe to our YouTube channel, and don't forget to like and share them.